Hi guys. We shared this thought that we are the last thing standing between the end of the day and drinks. But hopefully we'll try to make it as enjoyable and interesting to you as possible. My name is Monika Górska. I am an IP lawyer at Wardyński and Partners, and I have the pleasure of being a moderator for this panel. And I'm joined by some esteemed colleagues, all IP lawyers. But I will let them to introduce themselves. So let's start with the lady.
Thank you very much. I'm Lena Marcinoska-Boulangé. I'm, as Monika said, an advocate and IP lawyer at Wardyński and Partners. Thank you for invitation.
Hi everyone, my name is Georgi. I'm originally from Bulgaria, based in Sofia. I'm leading the intellectual property and information technology service line of our law firm across our 12 offices within the Central and Eastern Europe. And I'm also heavily involved in all our initiatives in terms of interactive entertainment and gaming, which of course includes video games as well, so that's why I'm here.
Hello, my name is Lobov. I'm a partner at Harbottle & Lewis in London. I co-head the games practice there, IP lawyer by background, which is why I'm here. Pleasure to be here.
Hi guys, I'm Michał Matysiak. I'm senior associate in Rymarz, Zdort, Maruta law firm, which is based in Warsaw. I'm also IP technology lawyer, and thanks for having me here today.
Yes, so thanks are in need actually. So thank you very much to Digital Dragons, to organizers, to Kraków Technology Park, and to Rymarz, Zdort, Maruta for organizing the legal summit. The title is about copyright and mechanics, and should we apply copyright to mechanics in games, and whether that's something that is practicable or not, whether there are any problems with this approach or not. I just wanted to quickly ask, are there any non-lawyers present? Okay, so the reason why I'm asking is that it justifies a small introduction of what is copyright, and that's what I'm going to do, because for only lawyers, I think that would be a bit too much. So copyright essentially is a law, and it's an exclusive right for creative authors, for authors to encourage authors to create, right? And the right itself helps you to stop others from imitating, from copying your right. So the underlying idea is you create, that's the incentive. You're an author, you create something, and if someone tries to copy it, if someone tries to use it against your will without your consent, you can stop that person, right? But the copyright also provides that not everything is copyrightable, not every idea, and that's the key word, not every idea is, the idea is not protected. The ideas are to be free, they're not to be owned by anyone, because again, the background story, let's say, is that the ideas are to be spread widely, and they are to encourage and to be a sort of incentive to others to build on those ideas. What is protected by copyright is the expression of the idea. So let's say the packaging of the idea, how it is expressed, irrespective of the form. So it's not a matter of whether I write it down or whether I paint it or just describe it to you, but the moment I express the idea, that the expression is protected. And this tension between protection of an idea, the tension between idea and protection of expression is really the core of copyright law and the core of all the problems that come with that. Do you agree? Did I miss anything? Anyone wants to add anything? No? Okay, so that's the general consensus on the panel that we know what copyright law is. But we are to discuss today, should we use copyright for mechanics in games? And the starting point should be, what do we mean by this term? What is mechanics? And Michał, can I start with you, please?
Yes, I see that Monika tries to throw me before the train with this question, because it's extremely hard and complex question. I believe no one came today to find easy answer, because it's not like easy question. I believe we need to start and making some kind of come back to the purpose of the copyright. We want to try to protect someone's creativity, to protect their economic interests, to protect their moral rights, and this is the main purpose. But from the other side, we want to make room for other people to develop some kind. For example, if you're thinking about more practical works, for example, to develop some kind of industries, etc. And we don't want to kill those creativity, but making really strict rules. And now I believe current regulations around the world try to make some kinds of compromise in that regard, and to make it fair and square, even for a creator, but also for the other parts that may get involved if they, for example, create some kind of derivatives, etc. So for me, I believe we should allow to copyright mechanics, but we need to probably ask the question whether we should think about mechanics itself, or other things that it's really connected to the mechanics, because there was a lot of cases, for example, in United States about that try to think what we really need to protect. But maybe someone else wants to shed some lights on that. I don't want to, because this is the topic of the mechanics, and making some kind of clones of the games, etc. is something that I also really invested my time when we're thinking about scientific work, because I make a lot of papers in that regard, and also my thesis on the university. So maybe I spare room for other persons, but I will be happy to jump on further.
Go ahead. So does it mean that mechanics is just an idea, or are you, when you're talking about mechanics, you're thinking about the expression of the idea behind the game?
Definitely expression, because I still want to stay in the current frames of copyright. I don't want make some kind of statements that we need to burn to the ground the whole institutions and to change our regulation. Yeah, definitely we want to protect expressions.
I just wanted to add that I'm not sure whether I agree with this division that you, Monika, provided, that within games we've got ideas that are unprotected and expression that is protected, because for me there is also third area, and this is exactly mechanics. And mechanics for me is not an idea, and this is not an expression. This is another component which is unprotected. And for me, I need to explain that, because it will be telling you, it will explain what I'm saying, things that I will be saying. For me, mechanics is nothing more than just rules, functionality of the game. In board games, you've got mechanics that allow you to move pieces, right? And tells you what steps are illegal. And in video games, you've got mechanics to allow you to move your character and not to reach the goal of the game immediately. So this is some kind of functionality, some kind of rules, what you can do, what you can't do, and everything that is beyond that is or could be an expression which is protectable.
I think that's absolutely right. I don't think anybody here is talking about, protecting or restricting the use of things like, you press W to move forward, you press S to move backwards, or, an isometric 3D adventure game. I don't think we're talking about that. We're probably talking about, and we cheated and discussed this before the panel, but we're talking about mechanics plus, something that sits in between mechanics and the expression. Possibly we could call it the gameplay loop or something like that. And that's the problem, because I think current copyright law is great at protecting stuff that you can see and stuff that you can rely on to identify the commercial origin of something, but it's not great at protecting how something feels to play, okay? Because it falls, in the opinion of many lawyers, closer towards the idea side of things rather than the expression. But the problem is, quite often, that sense of how a game makes you feel when you play it, the gameplay loop, is the thing that's valuable. And so when that gets taken by somebody else, and they of course reskin it, and they change all the artwork, and they haven't used any of the code, they've been very clever about it, but it still feels bad, right? And we all instinctively know when we see one of these games where it feels like, you know, it's a rip-off. You've taken a shortcut here, you've used somebody else's work, you've created something which is going to make quite a lot of money based on very little labor, and that feels unfair. I think that's what we're talking about here.
Georgi?
Yes, I would try to go a step back and actually to try to give another angle of what we are talking about. And first I will start with one general comment, and to explain why you hear me a lot of times to refer to the Central and Eastern Europe and to different jurisdictions, and why does this matter actually, and it is especially important in this case. Because I think that when we are speaking about game mechanics, there are maybe three main aspects. And I would not say whether we should protect it as a copyrighted work, but whether we could protect it as a copyright work. And what are the difficulties or the issues or the specifics there. On one hand, as we all mentioned, we understand something when we are saying game mechanics. But actually the question is whether we have a clear legal definition of this. Because otherwise it's just subject to interpretation of the different words, of the different courts, of the different jurisprudence. And I'll just give you an example, but and why? Because video games, they are not only global phenomenon, but they are a global product. I doubt that we are in Poland, but I doubt that there is a Polish video game studio developing a game that wants to distribute only in Poland and never looks at outside of Poland. So when they go outside of Poland, they need to know what is happening. So they need to know what is happening in Poland, but they also need to know what is happening in the countries they are interested in. So for example, in Bulgaria, in Serbia, in Hungary, in Croatia, in Slovakia, in Czech Republic, there is no legal definition of game mechanics. No legal definition of video games as well, but no legal definition of game mechanics. Okay, so now we need to understand what as we're talking about game mechanics, what does this mean? Most likely it would be methods, rules of play, but this is an interpretation. Most likely this will be copyright protected. So we are going to protect this under the regime of a copyright. And why, again, the jurisdiction matters? Because we could say that when you have a copyright protection, you are having a free launch, or you are having a free protection across the globe. You don't need to meet any requirements compared to like trademarks or patents, which they have like this territorial nature. You have a trademark and it's protected only in the territory where you have registered it. Yes, we can register across the EU and we can cover 27 countries. We'll see in the future. But when it comes to copyright, you just create it. And if it meets the criteria for a copyright, as you mentioned, they could a bit differ depending on the jurisdictions, but basically whether your work is original and whether it is a result of the creative efforts of the author. And if it meets this criteria, then it's copyright protected. And you can enjoy the same protection all around the globe. But we have here two types of countries that we need to keep in mind. On one hand, we have the so-called country of origin. In case of Polish gaming developing studio, this will be Poland. And they need to understand what game mechanics means under Polish law and how it could be protected. According to the international rules, if the Polish gaming studio goes to Bulgaria, it should enjoy the same protection. But Bulgaria will be the country of protection, where the protection of its rights is sought. And then the scope of protection would depend on the Bulgarian law. And if there is a difference between the understanding of the Bulgarian law and the Polish law, what does game mechanic means, then the Polish gaming studio might have some problems. because it could be safe in Poland, but could not be safe in Slovakia, in Czech Republic, in Romania. So if my takeaway from here is look at the countries, look at the definitions, and understand why does they matter and how you can use them, especially in terms of copyright.
Okay, but I want to push you a little bit on the idea. I mean, all of you panelists, on the idea of mechanics. I really need to go back to the definition, because for our conversation to have any sense, we need to agree on the term. And I kind of sense that we are shifting to something that it's not an idea, it's not the concept of the game. We're kind of talking, and I think that's what I picked up from what all of you said. We're actually, when we're thinking about mechanics, we are talking about expression. We're talking about some set of how we externalize the concept. Because otherwise, if we really wanted to copyright the idea behind games, behind the mechanics of the games, then there wouldn't be any games other than, I don't know, those already in public domain. So again, I'm going to push you back on the definition. So yes, we didn't discuss mechanics plus. So what would be mechanics plus in video games?
I think part of the problem, and the reason we're slightly struggling here, apologies everyone, is that we don't, as you rightly said, have a definition of video games. And I don't know why that is, because it's the most successful entertainment industry in the world. It's bigger than film and music put together. Yet we have a definition of film under English law. We have a definition of music works. We have a definition of even sound recordings. Even typefaces, fonts have their own definition and their own separate section in the Copyright Act, which gives them protection. Why don't we have a definition of video games, the largest form of entertainment? Sort of an open question.
Yeah, but from my side, I think I don't know whether like focusing just on the definition of video games is like the most important part of the discussion, because of course when we have like the definitions of other copyrighted works, for example, in Polish law, like for example movies, some kind of other audiovisuals, photography, etc. It's not like we always have like really precise definitions with all elements described clearly. Now we have like because it's like 21st century, we have like lots of court cases, lots of like books from lawyers, non-lawyers that try to make something from that and try to like investigate all the details of a specific copyrighted works. So of course, from the one side, I agree that there is because I'm a game dev lawyer, and for me it would be good to have like the clear regulation to help my clients to protect their work, and of course the lack of the definitions, the lack of the specific tools that address game dev problems, it's a bummer. But from the other side, I think that we could try to use also tools that we have nowadays, and of course in some jurisdiction, usually in United States, then try to find a way to protect something that we called here mechanics plus, because and if we like track court cases in United States, we see that they have the same way of thinking like us, from a board games like chess to the really simple mobile games to the more sophisticated, for example, games like a Street Fighter or Karate Kid, probably because it was like in the 90s or 80s, and there is like a whole thinking process and try to use the tools that we already have in law to protect. But of course, if we, for example, have like a clear definition of the mechanics, it would be a lot easier for us. But from the other hand, I was I also thinking about something that is a big problem of a copyright nowadays. Maybe not, it's not a problem, but it's a thing that we need to take into consideration. That, for example, nowadays we try to make really sophisticated IP clauses in the contract of our employees. For example, in for people that will not ever produce anything, but we want to like there is a slight probability that something may happen in the future, and of course we have like a really low level of like definition of creativity in the law. So there is the risk that we need to like make the whole IP clause for almost every employer to protect our clients. And this is something that, for example, if we make a definition of the mechanics, maybe I play here like someone like a devil's advocate, but this is hard because I know that after that, like the big companies try to secure their IP, and this is something that we need to also take into consideration.
I believe that we do not need any definition of mechanics plus. We need to learn ourselves and teach judges and court experts how to filter out mechanics from the other things that are protected. And I will give you an example, and I think that the great one is the Tetris case. I'm not a US lawyer, but this is a case from US 2012, Tetris against Xayo, the game Tetris and Mino. They were, we can say, clones. And I don't want to say that I disagree with the result of this judgment because the court said this is an infringement, but I disagree with the reasoning of this judgment because the court mentioned that, oh, these are those features, for example, I don't know, movement of pieces, and this is protectable by copyright. I totally disagree with that, and I cannot accept that.
Yeah, I think, you know, the problem with the copyright element of our question of the aspect that we are discussing is that copyright grants a really long protection, right? Because I think we all do agree that it's life of the author plus 70 plus years, 70 years after his death. So that's really very, very long for sometimes, as you said, Michał, for a creation that does not have to meet like very, very high standards, right? So I do agree that maybe copyright is not the best. Sorry, Georgi, I want to ask you a question about, if not copyright, then what else? Do we already have something that we could use, some other legal means to protect mechanics of video games?
Yes, just first to go back to what we said, I'm not advocating for a definition. I'm just saying that we don't have. If we don't have, we could have different approaches to this.
Lawyers love definitions.
Which is important. And also that's why I agree with you, Michał, that's why I said the question should not be whether we should protect by copyright, but whether we could, because we need to adjust what we have and we need to use what we have. But we need to understand what we have in order to use it right. Okay, if it's not copyright, I would say that if we all agree that mechanics is something related to methods, to rules, I would say that at least in the Central and Eastern Europe, we cannot use patents because, for example, in Bulgaria, in Serbia, patent protection is expressly excluded with respect to methods and rules of a game. So we cannot use it. In my view, we can think of some protection using trade secrets and some NDAs, but I would say that this is super, super tricky because the main requirement to have a trade secret is to keep it secret. So in many cases, these methods and rules, you can just not keep them secret. But depending, because we don't have a clear definition, depending on the mechanics, this could be it could be useful. And something else that I can think of is the unfair competition rules. The unfair competition rules could be good because they are quite broad. Almost any type of action could constitute unfair competition. And this could give us a lot of flexibility to try to build our case depending on which side we are, or to try to build our defense strategy. The tricky part here that I would like to to point is actually that again the jurisdiction matters, where we are going to protect our rights. Why? Because in order to use the unfair competition rules, we must first be competitors. We cannot use it just like this. And when we are competitors when we are competing on the same product market and same geographical market. These are the basics. I'm not going into details, but these are the basics. And even at EU level, to the best of my knowledge, since video games, they're not highly regulated like telecoms, for example, it would be up to the local competition watchdog to decide which is the product market. And in some countries, the competition watchdog would decide that if you're developing a PC game and a mobile game, you're still competing on the same product market. But there could be another watchdog who could decide that even if they are PC games, if they are in different genres, then this might not be a direct competitor to you, and you cannot use the unfair competition rules.
Kostyantyn, I wanted to ask you about unfair competition, because the concept is, I guess, quite known and similarly understood, interpreted in the EU. But what about UK?
Oh, we don't have it in the UK. We have passing off, which is the closest equivalent. This is kind of what I was going to say, which is the problem with unfair competition-esque type laws is that they are extremely fragmented all over the world. This is a global market. Games are launched pretty much worldwide when they're launched. And the problem as a rights holder, when you come across something that's been like a reskin, let's call it, within a few weeks of you launching your game, it's quite a tough decision to make. So you need to, analyze the most favorable jurisdictions where you might be able to bring an unfair competition action. I mean, it's easier in some than in others, but in some of the chunky jurisdictions, it can actually be quite hard. So in the UK, for passing off, you have to show that there's been a misrepresentation, which is likely to mislead the public into thinking that this game is commercially connected with this game. The problem is that unless you have rock solid evidence, like, I don't know, surveys or actual people saying, yeah, I was confused, I genuinely thought this was licensed by this, it's very, very difficult to prove. And this is what we're seeing in the UK, is a lot of passing off cases are being started and then just falling flat on their face because you can't prove that people are being misled, especially since we've had cloning and reskinning for a number of years now. This is not a new problem. I think people understand when they see something that's very similar, they know it's not licensed. They know this is not the same game, and they know this is somebody ripping it off and getting away with it. And that's where those sorts of actions end up being a little bit inadequate. They're flexible, but quite difficult to actually win on.
When we had our pre-call, we kind of wanted to be a bit controversial for your sake, and we asked ourselves internally, well, obviously copying is bad, and it's not something that should be maybe widely allowed and approved, but is there a line where we can draw and say, well, this is an infringement, and this is not yet an infringement? So I wanted now you to kind of comment on that our internal a little bit. I guess we had some different points of view with that question.
I'll very briefly be controversial and I'll say I think copying is good, but up to what kind of copying? Because actually all creative things, music, art, films, everything, it is all a form of copying. We talked outside where we talked about, copying from one source is plagiarism, but copying from many sources is research. That's what we were told at university. It's kind of the same here. Every music artist has, his or her own inspirations and things that they draw upon, and it's the same. But so that shouldn't be stifled, and that needs to be encouraged. But it's how do we work out when the copying has become the bad kind of copying?
I think the other thing, if we're talking about copying, because of course copying is good if we're thinking about development of specific things, because for example we copy some parts but add something that is really interesting for us, something that is really developed the whole work. But what I believe the most important question is, where is the line when I, as a creator, need to get a credit for in that derivative work, and the second thing, where is the line where I need, for example, give some kind of financial gratification, because this is like the most important thing. Because of course, a lot of for example, during a conference 2 months ago in Warsaw about like some kind of creativity in the light industry, one of the panelists said that he is okay with copying sometimes because he feel like it's some kind of attribution to his work, and from that side it's okay. But we need also to think about interests of creators, like for example financial interest and their moral rights. And if we done something right in that regard, the copying is good, but we need to find the level when this copying needs to be like additional pay to the author or make some kind of credit that this work is based on someone else's work, because this is if we're thinking like at the very beginning of the creativity of the authors of the whole like development of the culture. People want the authors, the creators want to, of course, have money for living, but also have necessary recognition for their work and their art, and this is two the most important parts.
There is apparently this sort of saying, right, that copying is the highest form of flattery. I think that's the proper expression.
Yeah, I just want to agree this time with what they said. I mean, copying is not that bad because, I mean, to the certain extent, because we know that everyone is inspired by someone. So if you are inspired by someone, you are copying part of the style, you're copying part of the characters or something else. You should just be careful not to do an exact copy of the work. Unfortunately, there is no, at least across the sea, there is no clear threshold or some clear legal test that could be followed by the courts to say, okay, that's copied or this is just an inspiration. But we should be aware that in some jurisdictions, I'm not a US lawyer, but for example, even in the US, you have like some interesting concepts like fair use. You have concepts like laissez-faire. In Bulgaria, for example, you have expressly included in the Copyright Act exclusion from copyright protection, saying that you can imitate the character and the style of a work, but at the same time, this exception has its own limitation, and it says that this does not apply to computer games, to computer programs. And then again, we are going back to the video game definition, because we all know that video game consists of different elements. Underlying software is one of them, but not the only one. Yeah.
Lenka, imitation or copying?
I
Good,
must admit
good,
that I would say that's rather good.
Inspiration.
Yeah, inspiration would be the best. But frankly speaking, for me, it would be the best if like developers would have like clear tests, clear guidelines to decide on their own where is this line. Because sometimes me as an IP lawyer, I can't say that really. In the past, I would say, okay, you can take general idea, you can take general mechanics, but now. Really, with this jurisprudence that we have, court cases, I'm not sure what should I say. You can take general mechanics, but you can't take movement of pieces. It's really difficult now.
Okay, so I don't know what's the time, I'm sorry. So I don't know if we have still a lot of time or not. But I also wanted to ask you, so going back to Georgi, statement or proposal that we need a definition or that we need some provisions in law that concern video games. Do you think? I mean, firstly, do we really need that? And secondly,
you can't ask him.
I want to say I'm going back to what Georgi mentioned. But so, do we need it? And if so, do we need it in copyright? Copyright law, within copyright law?
I would say that I would agree again with Michał that we need to use what we have. We need to learn to adapt the existing legislation. I mean, when we're speaking about do we need new legislation, do we need new definitions, again, we should draw a line. Because if we have too many legal acts, we may limit the creativity, which is a big part of the copyright and big part of the video game industry. So we should be careful. My point is that in addition to that, we need to use it. Yes, if we have a definition, this could help. Of course, the lack of definition currently is giving us some flexibility. I agree with this, and this could be good. But at the same time, if you have a definition for some of the aspects, the elements of a game, it could help.
I think, you know, a new law or rewriting existing law is a nice kind of North Star, maybe on our wish list for the very, very long term. But you're all absolutely right that even under the existing law, the existing frameworks, a lot of the rights that are already here are being underused. So CoFML, there was a case, I don't know if you've maybe heard of it, a few years ago now, which kind of opened up the concept of what can be protected by copyright, which is basically anything which is original and you can define it with sufficient precision and objectivity. So in theory, if you've met those two criteria, the CJU says you can have it protected by copyright. And this was a pre-Brexit decision, so this also applies in the UK, which has caused havoc with our law, because in our copyright law, you have specific types of copyright work, and you have to fall into one of those. And if you don't, the law says you're not protected by copyright. But of course, now we've got this CJU decision, which we're bound by. So actually, there's a conflict. And there's been, I think, 3 opportunities for judges to resolve that conflict, but they've all just sidestepped the issue because they don't want to have to deal with it. So we've had a case where there was a character as a whole, not just the descriptions of the character or pictures of the character, but the character as a whole, the idea of the character, I could controversially say, was held to be protected by copyright. But instead of saying, oh, and by the way, English law now says that anything can be protected by copyright, you don't have to fall into one of these buckets, they just said, oh, well, that character is a literary work. We're just going to call that character a literary work, which makes no sense, because obviously it's a lot wider than that. But yeah, that's the situation we're in. So I'd like to see more cases, more people attempt. You know, there's been one attempt in the UK where there was an attempt to argue that the video game as a whole is a copyright work, and somebody tried to rely on that, but it didn't go to court, didn't go to trial, so it was never tested. So I think in theory, if we had more like that, then we could, you know, the courts could give us the guidance that we're looking for rather than actually having to rewrite any law.
Lena, Michał?
Yeah, maybe I drop one more comment, because something what Kostya said is really important, because one of the most like the biggest problem of Polish law, if we're thinking about like computer video games, whatever we called them, is the fact that because of the lack of the definition, there was a lot of papers, a lot of books about how we try to fit the games into our legislation, and for example, which tools already covered by copyright will do their work if we're thinking about computer games, and like this thing to like discuss whether this we need to think about the computer games like it is, for example, one specific big creative work, or for example, this is like the complex work that consists a lot of smaller parts, which for me is a better approach, because it's really similar like in case of the movies, because of course we have some kind of visual layer, we have like music layer, we have, for example, text, etc. So it's better, but making a definition usually leads us, for example, to also include some other provisions that, for example, would help our industry branch. For example, we have regulations related to other types of work that is really similar, like in the United States, something that is called work for hire. And now we don't have like something really related to like the whole complex work like computer games. Of course, we have other provisions, for example, related to for example, computer programs, etc. But this is something else, and maybe like implementing some kind of specific regulation, maybe not really harsh, but just to make some tools, some regulations that makes developers' life easier.
Lena?
So I think that having the definition of video game, it would be great to have it, but I would not put it into a copyright law. I think that such a definition would solve many problems, for example, with taxes, with other regulations. But I think it's impossible to have this definition, and I don't want to be controversial, but one thing is that it's impossible because we, as a sector, slept this moment. Now everybody is talking about AI, and we are discussing definition of AI, not video games. But even having this definition somewhere, and getting back to the original topic of our panel, I would exclude from protection ideas and mechanics. I do not see any justification why we are to protect functionalities of the games, whereas we are not protecting, I don't know, functional features of medical devices. It would be unfair. But if we've got the definition, and as you said, if we would like to protect the game as a whole, I believe we should significantly shorten the term of protection.
So I was about to say that I kind of agree with you on maybe the need for the definition, although, as I've joked before, lawyers love definitions, and we would probably have another panel in 2 or 3 years discussing the definition of a video game and how it's understood, and all the differences and all the different possible interpretations of elements of the definition. But I think, it's nothing new. I mean, we've heard this argument being raised against software, that at least under Polish law, that was maybe one of the not the smartest decision possible to include software and computer programs under copyright and granting such a long extension, such a long protection, right? Because computer programs are just an evolving, software is evolving all the time, right? So it's quite difficult to pinpoint the exact moment that this particular piece of code is now protected for life of the author plus some 70 years, right? So I would say, I think, Lena, I agree with you that if we are to introduce a definition of a video game or of any elements of the video game, maybe then shorten the term of protection. Obviously, there'd be a lot of discussion among the industry leaders whether that's okay or not. But I'm also wondering whether we have not reached the moment where video games deserve their own legislation, like not really trying to push it into copyright, but really just having a separate act. Because I guess it would solve some of the issues that, for example, under Polish law we have with work for hire, or the employer gets everything that employee creates, and all those provisions that are general but not applicable to software, and et cetera, et cetera. I think, we do agree that video games are such a complex issue that maybe they deserve a sort of separate legislation. What do you think? Do we want a Video Games Act?
I mean, sure, it would be great, but I just don't think it's ever going to happen, because it's so specific, and you just never get people to agree. Well, you'd struggle to get people who are actually in a position to make new laws to take it seriously. We're still struggling with it today, despite being the biggest entertainment industry. We still come across, crusty old white men who just don't understand what it is, and unfortunately they're the ones in power, so we need new generations of younger politicians who grew up with video games before we can even dream of any of this happening. But the other problem is, of course, the international dimension, which Georgi mentioned. I think fundamentally there is a very different approach or kind of social understanding as to what should and shouldn't be protected as you move around the globe. So you look at attitudes to protecting creative output, like in the UK or the US, and you compare it to, I don't know, Russia or China or somewhere else. You'd get very different answers as to whether or not copying is good or bad, or at least at what point does the copying become bad. That line will be in a very different place.
Georgi?
Yes, first I would, to what Lena said, if we say that ideas are equal to mechanics, I would say no protection for ideas. Personal opinion, we should not say that they are equal, and we should not protect ideas. This will limit the creativity, and this is not the idea of the legislation, and it has never been At least I'm doing this for 15 years, at least in my time, and to the best of my knowledge, of course. But something I would repeat myself, but I do believe that we need just to try to adapt to what we have, to the reality, and we should not. I mean, I'm not a legislator, and this is really serious topic to decide whether we need a new legislation or not. Interestingly to say, and I'm happy to say that I found one aspect in which the Central and Eastern Europe is in a better shape than UK. So it's our copyright acts, they do not limit the work. So it's not an exhaustive list, which actually provides for the opportunity to protect anything to the extent it complies with the requirements. So that's why video games are protected as copyrighted works, because the list is not exhaustive. And if they comply, they will be protected. The tricky part here is exactly what Michał said, work made for hire, what you mentioned, this to whether it belongs to the employers or not, depending on how we look at video games, whether they are a unique, united, complicated, complex IP work consisting of many works but protected as one work, or the other way around, as consisting of many different elements, each of them protected as separate element by the IP law depending on the element. This could have had an effect on the ownership, whether it could be covered by a work made for hire or not, whether it could be similar to movies or not. And that's why we need to see how to actually adapt what we have, and maybe with some slight adjustments to make it work.
Okay, I think, yeah.
I was just going to say, I'd love to hear from some of the non-lawyers in the room as to whether they, sorry, that's probably what you were going to say.
No, I was about to say, well, that I think we more or less covered all the points that we wanted to share with you. I guess to sum up is that with mechanics it's not as easy as it seems. Unfortunately, I know it's not a satisfactory answer, and I think we need really either a court case or a proper litigation to come to have a sort of indication in which direction to go, whether the judges and the courts understand mechanics in a very narrow sense as just ideas and just concept, or it's a broader term which could somehow also encapsulate the expression or the gameplay and everything that we said. But we are lawyers, and so that would give us some guidance. But yeah, let's now turn to our audience, and if you have any questions.
Something.
Yeah, so I wanted to ask about something a little bit different. To this part of the panel, which is on the side that you should allow for copywriting game mechanics. I wanted to ask you whether you think we should also, or could also, or would have to copyright monetization mechanics, such as loot boxes, battle passes, and so on.
Anyone? Or do we answer? It depends.
Yeah, I think this is the best answer to this question. But
and it's for free, Janek. It's for free.
Yeah. I think we need to use the same approach as always to try to find relevant aspects of this monetization and try to fit it to current regulation, because maybe in some way it could be, for example, protected, maybe not on the level of the copyright, but we can use, for example, different legal acts. But this is really hard question if we want to like use a simple answer to that, because there could be so many factors that matter in that case that could lead us, for example, we start from the really easy question whether we copyright, for example, some kind of mechanics like that, but after like thinking about like the whole picture, thinking about the aspects, thinking about elements like for example some kind of visual reflection of that mechanism, that will be there will be like an ocean of possible smaller elements that we could to protect somehow. Maybe not in using copyright, but for example, unfair competition rules, etc.
And I think, Janek, it depends on. I mean, what you want to protect in particular? Because when you ask this question, I just remembered that, for example, there are some patents, and we did exclude patents because it's really difficult to get a patent on a sort of method of game. But there are some patents, even in Europe, there are some patents that try at least to protect some instructions, or the implementation, the computer implemented invention, right? So there's a lot of probably phrasing and legal work going into the description of the invention. But I guess, depending on what exactly you would like to protect, maybe even patents. Obviously, it comes with the only limited protection period, but maybe that could be your answer to your question.
I believe a good example of that is the whole Nemesis system, which was implemented in Shadow of Mordor. When we have when we have patent for, maybe not we, but Ubisoft probably, as far as I remember, to cover this very complex mechanic, whatever we call it. But it was like a great solution, and they think. And they use this type of protection, like industrial property law, to make something to use this mechanic in, for example, in the future games or something like this. And they want to exclude it whole other companies from using this solution, because it was so innovative.
But also rest assured that if it is patent protected, there will be probably people trying to undermine the patent or go around it, or go around claims, and they will use the exact solution otherwise.
And just one comment from my side, again, if the idea of your monetization or the concept of the monetization, you cannot, but otherwise you can try. I mean,
Jarek, there was a question, I think, somewhere in the beginning, in the front. Sorry.
Hi, thanks for the panel, because it's great to see how ideas of law can affect business, and thank you for that opportunity. And being that in mind, I would really ask, because the question is, should we allow the copyright mechanics in video games? Well, bearing in mind that law actually is about balance and introducing balance into the world. How copywriting mechanics would affect the current business? How do you think? Because plenty of companies would seek this opportunity to abuse the mechanics. They have plenty of dead games in their portfolio that they could use to monopolize the market. How could we not allow them to do that, or how we could not be affected by that? Thanks.
Anyone?
Yeah, I mean, this is what we were getting at earlier, that if any changes are to be made, and there is an argument, I think we all agree that maybe no changes need to be made, because we should just learn to use the existing law and stop complaining about it. But if any changes are made, then we need to be very careful about those changes, and they need to be very incremental. So perhaps having a reduced duration or very strict limits, because you're absolutely right, that is the danger. The danger is that it stifles creativity. The big players make a grab for it, they grab everything they can, and everybody else is left in this kind of chilling effect, shadow of doubt as to whether or not they're infringing, and it just kind of reduces the creativity overall. So yes, that's the danger here, absolutely.
And I would like to add up on what Tomek said about the balance of the copyright, and I completely agree with what you said. And I recently heard an idea of talking about mechanics from a perspective like not the single rules, because the single rules, of course, are excluded from protection, but when there is a specific set of rules for the video game, which is expressed in a very peculiar, very innovative, very distinctive way. From that angle, shall we see that kind of mechanics, not taken like a single bits of mechanics, like moving forward, moving backward, jumping or crouching, but the overall, for instance, the game loop, the entire game loop of so many mobile games are mechanics. These are mechanics, but the mechanics are very much sophisticated. And the way that we look at the copyrights from the current perspective is basically, to some extent, a little bit schizophrenic, because the same copyright law in many countries says that, well, if you take those 3 single pictures out of the game that was already on the market, you infringe on the copyrights, and you can be sued. But if you take the entire gameplay and just add this as a reskin, that's completely fine. So coming from the balance perspective, is it really fine?
Well, this is a practical tip, and this is what I advise clients at the moment, is that, you know, in the TV industry, specifically the TV industry, they have these things called format Bibles, which you may have come across. So this is where you have, for example, a game show or a particular type of TV show, and you want to define in a lot of precision exactly how the show is supposed to work, the rules for the show, how many contestants, how does it flow, you know, who has the microphones, etc. And they put together these extremely detailed, digital these days, Bibles, which just have loads and loads of documents explaining this in a lot of detail. The reason they do that is because TV formats have historically been very difficult to protect for the exact same reasons that we're talking about now. But this improves their chances, because it improves their chances of arguing under existing copyright law that here's my specific copyright work, here's all the work that I've put in defining exactly how it should be, and if somebody else is doing something similar, I now have a really good chance of arguing that that infringes this.
But I think, Michał, to answer also your question, that goes back to what is mechanics and what do we understand by it? Do we talk about expression? And I think the approach to trying to protect formats and describing them in as detailed as possible is just trying to meet this expression criteria rather than just leave it as general as a concept, right? So I guess, you know, for me it would depend, unfortunately to some extent it would depend, the protection and everything would depend on how the idea is expressed, how in what detailed it's expressed, as detailed it is. But I also agree with Tomek, your thesis that if we say, without really challenging this concept, that mechanics and in the general concept are protected by copyright, then we will have the copyright trolling, and we already know that it exists, right? And sometimes it's a real problem, and it's not only and it doesn't come from a good place in the sense that we really do want to protect our game and everything. It just comes from sometimes, you know, from the place of, oh, we're not using it anymore, but we want to stifle the innovation, and we don't allow development in the sense of being inspired or something. So I think the problem is maybe that, yeah, we should go back to origins of copyright and try to strike a balance between the incentive to create and the reward for the creator, for the authors, and also the shield against copying. I don't know. Any other questions? Yeah.
May I have another one? Okay, thanks. So, because I don't want, I know there are not only lawyers in the room, so I wanted to show an example to ask my question, because while I was hearing and listening to you during the panel, I couldn't stop myself from thinking about poached eggs. So, when I make a poached egg, I boil the water, I add vinegar, and I stir it till it's done. So basically this is how mechanics could work, yes. So when we are talking about allowing to copyright mechanics, should there be a body to decide whether I steal it left or right, and that's my original idea, or should it be protected from its original, like a painting or other creation? What's your take on that?
It depends on the
it depends. Yeah.
On the jug, on the what is casserole? Or no, what's the English expression of the
way? So they have this issue again in lots of industries, not just in games. And the way it's currently resolved, which you might feel is totally inadequate, is we have the originality test, and the originality test is supposed to filter out stuff that's doesn't meet a minimum threshold of you've put enough work here to create something that's original and worth protecting, versus stuff which actually kind of meets the test. The problem is, as you said, the threshold is very low at the moment. Certainly in Europe, the originality threshold is extremely low. I could draw a doodle on a napkin right here, and that's protected for 70 years until after I die. And you could argue that maybe needs to be a bit higher. But yeah, that's currently how this... And there will always be ambiguity in the law because we can't have specific... As much as we talk about definitions, it's impossible to define stuff because everything moves forward. Technology moves forward. This discussion will be totally different 10 years from now. We'll be talking about something else. So there has to be built-in flex in each piece of legislation. And in the context of copyright, that flex is originality at the moment.
Any other questions?
Well, I guess people are overloaded with information by now. And let's give a round of applause to our speakers. Thank you very much.